Hello, my name is Brad Biddle. I serve as outside counsel for the OPC Foundation. In connection with OPC Day International, I'll be discussing standards, intellectual property rights, and the OPC Foundation's MOCA, or Multi-Organization Collaboration Agreement. Some background about me as a quick introduction. I am the principal of a small law firm that supports a number of different standard-setting organizations and open source foundations, in addition to the support we provide to OPC Foundation. Prior to launching this firm in 2015, I was standards counsel for Intel Corporation and ran a group there called the SIGs and Standards Practice Group. I'm also a faculty fellow and occasional adjunct professor at Arizona State University School of Law, and I've published a number of articles on standard setting that you can find on Google Scholar and elsewhere. I'm also the editor of a book published by Cambridge University Press called Patent Remedies and Complex Products. I find standards fascinating because they lie at an intersection of complex legal issues, complex business strategy issues, and complex technical issues. As a lawyer, I find it quite important to understand the business and technical issues as well as I possibly can. And my hope is with this talk to help those of you who are coming from a business strategy perspective or a technical perspective to understand some important legal issues as well as I can explain them. I'm sure that all of you are familiar with new business and technical challenges that have emerged as a result of the increasing convergence of the IT and OT industry segments. There certainly are also some legal issues that have emerged or at least are being repackaged as a result of this convergence. Probably the most important set of legal issues that have emerged relate to intellectual property rights, or IPR, which is best thought about in terms of its constituent components of patents, copyrights, and trademarks, or also trade secrets, which I'm not going to discuss today. I'm going to focus first on patents. A patent embodies an exclusive right of a patent owner to use a particular invention or to require that anyone else who desires to use that invention pay some sort of royalty to the patent owner. The way this can arise in the context of standards is you can imagine a number of different participants, each contributing different features to a specification labeled feature A, B, and C here in the diagram. If you imagine that the party who contributed feature B could have a patent that reads on that particular feature, and perhaps in this example, there's an additional party who may have a patent that reads only on a combination of feature A and feature C. So when these features, A, B, and C, are embodied in a specification, and an implementer then implements that specification, the implementer risks potentially infringing patents the A and C in this case, or patent B, and so forth. So in the context of standards, a fundamental concern of implementers is, am I licensed to, or can I get a license to, applicable standards essential patent claims, or SEPs, and under what terms? The risk of an implementer not being licensed to applicable SEPs is well recognized as a high magnitude risk, in the sense that by the time an implementer discovers they're unlicensed, they may have significant sunk costs invested in implementing a particular standard and few realistic alternatives. Historically, however, this has been a relatively low likelihood risk, at least in the OT environments. And it may be because the OT industry segment is different in some material respects from other industry segments where this has played out differently, particularly the telecom industry. There are some good reasons to think that the risk profile associated with standards essential patents is changing in the OT industry segment. Parties that study these issues have noted that the number of SEPs generally is increasing, the amount of litigation around SEPs is increasing, and that some of this litigation is focused on smart factories and other aspects that are related to OT-IT convergence. Intuitively, it's not hard to understand why SEP litigation may be increasing. Parties who have made a business out of collecting a 2 or 3% royalty on a $400 handset are now seeing that there's a similar opportunity to collect a royalty, perhaps a similar percentage, based on a $140,000 car or potentially a $1 billion factory. So there's real money at stake. Additionally, parties outside of telecom increasingly seem to be looking at that business model of collecting SEP royalties and seeing an attractive business model in connection with standards other than specifically telecom standards. So again, we see that this implementer concern of being licensed or being able to get a license to applicable standards essential patents is really fundamentally important. Different SDOs or standards development organizations address this issue in different ways. Surprisingly, some just ignore it and are silent about patent issues. Some focus on disclosure obligations. The model is that parties will disclose known patents with the idea they can commit to license, or potentially the organization can design around those patents in advance of the spec being finalized. In my view, this reflects a somewhat naive notion that it's possible to identify all applicable patents in advance of closing on a specification. Historically, in the OT space, there's been a model that required participants in an SDO to assign ownership of their essential patents to the SDO, or alternatively grant a broad sublicensable sublicense to the SDO, which the SDO then could license out to implementers either for free or for a royalty. In the ICT space, the model typically is that the SDO participants promise to, or in some cases automatically grant, a license to all implementers, so long as the implementers agree to a reciprocal license. Very importantly, these license terms fall into two broad categories that are different in important ways. The first category is what's sometimes called FRAND or RAND, which are essentially equivalent terms. And the idea is that under a FRAND or RAND policy, all participants are obligated to grant licenses on reasonable and non-discriminatory terms that potentially can be royalty-bearing. The other large category of policies are RAND 0 or RF RAND, royalty-free RAND, or quote, royalty-free, unquote. All of these terms are essentially synonyms as well, and as implied, the key feature of a royalty-free policy is that there are no royalties. Over 3 years ago, back in 2018, OPC Foundation made a major change to its IPR policy. We transitioned from our version 1 IPR policy to a version 2 IPR policy. Our version 1 policy was the old school style OT policy where OPC Foundation was positioned to decide what patents were essential. Once OPC decided a patent was essential, then a member would be required to assign ownership of that patent to OPC Foundation, or alternatively grant OPC Foundation a very broad license. There would then be additionally some complex disclosure obligations applicable to all members. The challenges we faced with this policy were, first, that it put OPC Foundation in the middle of patent disputes between its own members, where OPC would be required to adjudicate whether or not a particular patent claim would be deemed essential, and then to force a member to grant ownership of that patent to OPC Foundation if it did. We also found, perhaps even more importantly, that patent owners were simply unwilling to agree to this policy, particularly those coming from the ICT world, so it was inhibiting the growth of the organization. We changed in 2018 to our version 2 policy, which is more of the ICT style of a default royalty-free RAND commitment that's applicable to all members and other participants, and which includes an obligation to all implementers, subject to a reciprocity obligation and some defensive suspension rights. there is the ability for participants to opt out of the default RF-RAND rule prior to a spec being finalized. Our version 2.2, it reflects an update that we did to ensure that these rules apply both to OPC members and to non-member participants who are engaged in OPC Foundation activities. As we were working on our IPR policy revisions, one challenge we noted was that in the industrial automation world, there's a remarkable amount of cross-organization collaboration, really unique in this space, different from other industry segments. One reason why I think this kind of cross-organization technical collaboration is rare in other industry segments is that it's quite difficult from an IPR point of view. The challenge is, you can imagine that if parties from one organization have committed to an obligation along the lines of the OPC Foundation terms, I promise to license my essential patents to any implementer on RF-RAND terms on a reciprocal basis. But then another set of contributors have made a different set of licensing promises, more say the old school model of I promise to license my patents to my SDO, and that SDO can then license them to implementers. And then a third set of participants make a different set of promises still, like I promise to license my patents on RAND terms and only to other members of my SDO. And then perhaps other participants still operating under no license commitment at all. The key and obvious question for an implementer is, am I licensed, and under what terms am I licensed? Our strategy for addressing this issue in OPC Foundation has been a document that we call the MOCA, the Multi-Org Cooperation or Collaboration Agreement. It's a relatively short document, just a few pages, but we also have a one-page overview that's available on the OPC Foundation website. A key feature of the MOCA is that it incorporates the OPC Foundation IPR terms. And the reason for this is simply because they fit well to the circumstance of multi-organization collaboration. They explicitly impose SEP licensing obligations both on members of OPC Foundation and on non-member participants who are engaged in collaborative activities with OPC Foundation. The licensing commitment that all parties make is to all implementers, not just members of OPC Foundation or any other particular organization. The obligation is an RF-RAND obligation, so a royalty-free obligation with an opportunity to opt out of that default RF-RAND obligation before a deliverable spec is finalized. This is an approach that's fair to SEP owners and also maximizes adoption incentives for implementers. And the reciprocity commitment from adopters that's imposed by the policy helps create a robust royalty-free ecosystem. So all parties who are implementing the spec are obligated to a royalty-free licensing obligation. Ultimately, everyone benefits from this clarity. Having a single set of terms that are applicable to all implementers helps all parties understand their rights and obligations. In addition to the OPC Foundation IPR terms applying, participating organizations can also adopt project deliverables under their own IPR terms. So nothing about the MOCA approach prohibits other organizations from applying their own IPR terms in addition to the terms that are imposed via the MOCA. Patents are certainly the most high-stakes component of intellectual property in connection with standards, but copyrights are also quite important. Copyrights apply to works of authorship, so documents or similar works, and provide an exclusive right for the copyright owner to reproduce, distribute, or create derivative works of that particular work. OPC Foundation's original IPR policy required that members assign ownership of copyright in their contributions to OPC Foundation. We increasingly found resistance to this point, though, from parties who pointed out that this would mean that they couldn't reuse material that they themselves created. In our revisions to the IPR policy, we switched to a more typical model that we see in the IT world, where contributions are licensed to OPC Foundation. OPC Foundation can then combine contributions into some kind of compilation, which there's a layer of copyright that applies to the compilation that's owned by OPC Foundation, but the individual contributors continue to own and control the works that they themselves created, and they can reuse those works elsewhere. In the MOCA, we follow the copyright rules of the IPR 2.2 policy, so participants do grant a license to OPC Foundation. Additionally, however, OPC Foundation then grants a broad license back to our partner organizations. And this broad license includes the right for the partner organizations to take the deliverables from the collaborative process and create derivative works of those deliverables independently of anything they're doing with OPC Foundation. The last component of intellectual property that I'm going to speak about today is trademarks. Trademarks are typically a word or a phrase or a logo that's used to identify the source of goods or services. In the context of standards, they can also be used to perform a certification type function. And there are special flavors of trademarks called certification marks that are specifically designed for that purpose. The potential importance of trademarks in connection with standards is underappreciated in my view. The power to name something can be quite important, particularly to name a definitive version of something. The example I like to use is Android. So Android's based on underlying code that's freely available to anyone, but Google was able to build a remarkable ecosystem around Android, largely using the power of licensing the mark, both the name and the logo. In connection with the MOCA, we address trademarks only in a very minimalist way, granting licenses to create co-branded deliverables, but any other issues associated with trademarks or certification marks are deferred to some sort of separate discussion. To quickly summarize a few key points. First, I hope it's clear that the legal issues associated with standards are as rich and interesting and complex as the business strategy and technical issues that perhaps you are more familiar with. Also, the SEP risks that we've been discussing are very high stakes in terms of dollars, and changing rapidly, particularly as OT and IT worlds converge. Additionally, I hope it's clear that collaboration between organizations, deep technical collaboration between organizations is quite difficult, I'm sure from a business and technical point of view as well, but certainly from a legal IPR perspective, it's very hard for organizations with different IPR terms to collaborate with each other on technical matters. And the solution on the OPC Foundation side is the MOCA, which we hope thoughtfully addresses this complexity. Thank you very much for taking the time to view this presentation, and I welcome your comments or questions.